Hi, everyone, and welcome to another George Consortium COVID-19 Law and Policy Briefing. Really happy to be with you today. It's presented by our colleagues around the country who work in public health law in association with Public Health Law Watch at Northeastern University and the Center for Public Health Law and Research at Temple University. We are here to provide expert legal analysis during the COVID-19 pandemic and hopefully to answer some of your questions. My name is Gable. I'm going to be the host for today's discussion, and it gives me great pleasure to welcome two really smart colleagues. With me today are Professor Stacey Tovino, who's a professor of law at the UNLV William S. Boyd School of Law, and Professor Leslie Francis, who's a professor of law at the University of Utah School of Law. Our topic today that we're going to be delving into in great detail over the next half hour is how health privacy is going to work during the COVID-19 pandemic, how health privacy laws apply, what exceptions might come up. And obviously, privacy is an important right in our society. It's particularly important when we're talking about how it applies to health information, which can be sensitive and can lead to potential discrimination and stigma if that information is revealed without permission. And so I wanted to start with a very basic question. What are some of the reasons that so much attention is paid to health information privacy? And I'll direct that to Leslie.
So Lance, you started out with core reasons. We're really talking here about control of information. Some people would prefer to call that confidentiality, but the HIPAA Privacy Rule calls it privacy. If information gets out without your consent, it could affect your employment. It could affect your insurance status. It could affect your reputation. It could affect your relations with others. It could affect your physical safety. It could affect your sense of personal integrity if people shame you over the internet or in some other kind of way. I want to emphasize here that HIPAA is not just about privacy, though. It's also about data security. And people don't think about the security issue as much. Nobody really cares about what my husband said to his dermatologist yesterday, but people really might like to steal the social security number and date of birth, which he can't change, which are in his electronic medical record. So don't forget security, but confidentiality and security are what we're talking about.
Okay, and I wanted to get Stacey into this discussion here to talk a little bit about how health information privacy is protected under the law. And so, how does the law protect health information privacy?
Well, the short answer is that in the United States, unfortunately, it's a patchwork of federal and state law. Of course, at the federal level, we do have the HIPAA Privacy Rule, which protects most individually identifiable health information that falls within the definition of protected health information, or PHI. But as many of us know, the HIPAA Privacy Rule is limited in application to only covered entities, including health plans, healthcare clearinghouses, and not even all, but only certain healthcare providers, those that transmit health information in electronic form in connection with certain standard transactions, including the healthcare claims transaction. The HIPAA Privacy Rule also applies to those covered entities' business associates, but many of the individuals and institutions and applications that I'm reading about on a daily basis in the news that are using, disclosing, sharing, and collecting health data, including COVID data, they are not covered entities, and they are not business associates, and they are not regulated by our federal HIPAA Privacy Rule. Now, we do have several pending federal bills that are designed to remedy the limited application of the HIPAA Privacy Rule in one way or another. And these include, but certainly are not limited to, the Smartwatch Data Act, the Protecting Personal Health Data Act, the Mind Your Own Business Act, and of course the Data Care Act. These all were introduced between 2018 and the present, but so far I have not seen a lot of excitement in terms of their enactment, especially now that we are during a pandemic. The last thing I'll mention is that at the state level, with the exception of general data breach notification laws, which every state has, and with the exception of state secure disposal laws, which about 2/3 of states have, And with the exception of certain jurisdictions like California and Texas that do have pretty robust data privacy, security, etc. provisions, in general, at the state level, privacy is done on what I call a health profession by health profession basis. For example, Medical Practice Act and Nursing Practice Act that apply to doctors and nurses, or what I call a health institution by health institution level. So, for example, hospital licensing laws and nursing home licensing laws. So it's really a patchwork of federal and state law. It's not great.
Well, thank you. That's a really great foundation to turn to our main topic of discussion for today, which is how the COVID-19 outbreak is affecting health information privacy and some of the changes that have been made already in response to this outbreak. So about 2 weeks ago, or 3 weeks ago now, I guess, Secretary Azar of HHS waived sanctions and penalties that could otherwise be imposed on a covered entity's violation of certain provisions of the HIPAA Privacy Rule. So, Stacey, what were some of these changes and how do they affect application of the rule?
That's a great question. So there are now 5 provisions within the HIPAA Privacy Rule for which the Secretary of HHS has waived sanctions and penalties for noncompliance by covered hospitals, not other covered entities, only covered hospitals. These include, first, the regulation at 164.510A, which is the HIPAA Privacy Rule's requirement to honor the request of a patient to opt out of being in a hospital's facility directory. I'm going to take my headphones off at the request of faith. As background, covered providers like hospitals are supposed to inform patients in advance of the pieces of information such as name, location within the facility, general condition, and religious affiliation that may be included in a facility directory. And they're supposed to give patients the opportunity to opt in or to opt out of being in the facility directory. And HHS has stated that he is waiving sanctions and penalties that may be imposed on a covered entity for, in his words, failing to honor a patient's request to opt out of the facility directory. The second regulation for which HHS has waived sanctions and penalties for noncompliance is 164.510B, which is the requirement to obtain a patient agreement or non-objection to speak with family members or friends involved in a patient's care. And I know Leslie has great expertise in that area, so I'll leave that to her. The third regulation is 164.520, is the notice of privacy practices requirement. The fourth regulation is 164.522, which is the right of a patient to request privacy restrictions. And the fifth regulation is 164.522B, which is the right of patients to request confidential communications.
Yeah, so just a quick follow-up to that. When do these waivers become effective and who do they apply to? Or do they apply across the board in all hospital settings, or is it more limited than that?
That's a great question. They became effective at 6 p.m. On Eastern Standard Time on March 15, 2020, but the waiver was made retroactive back to March 1, 2020, and they will continue until we are no longer in a presidential declared nationwide emergency or until we are no longer in a secretary declared public health emergency. And no, they don't apply to every hospital. They only apply to those hospitals that have instituted a disaster protocol, and they only apply for 72 hours, so for 3 days after the hospital has implemented its disaster protocol.
Yeah, so this seems like a fairly unusual situation. I mean, obviously the pandemic we're facing right now is unprecedented in our lifetimes. Is this the first time that HHS has granted these kinds of waivers for the HIPAA privacy rule, or has this happened before?
This has happened before. We see this a lot in the HIPAA world. In September of 2005, for example, we saw HHS exercise enforcement discretion during Hurricane Katrina. Again, in 2017, when Hurricane Harvey hit Texas and Louisiana, we saw the Secretary of HHS waive penalties and sanctions for noncompliance with these same 5 regulations. We saw this again also in that same year with Hurricanes Irma and Maria for Florida, for Puerto Rico, and for the United States Virgin Islands. And to give you a non-hurricane example, we saw this again in October of 2017 during the California wildfires, when the secretary waived sanctions and penalties for non-compliance by covered hospitals located in California.
Okay, thank you. So I want to get Leslie back in the conversation here, and I also want to talk about a couple of specific examples, some ways that this rule might apply in some real settings that people might expect to see or face over the next couple of months. So Leslie, is it a HIPAA violation to use information gathered about one patient to treat another? So for example, what if one family member is known to be infected with COVID-19 and others present with symptoms? Can that information about the first family member be used in treating the other without notification of that first person?
So first of all, it's really important, because if testing is still not fully available, that information could be enormously useful. So let's just put that out there. In the original preamble to the HIPAA Privacy Rule, HHS stated that for treatment didn't necessarily just mean this patient. It meant for treatment of any patient. Now that may come as a huge surprise to people, because that's not explicitly stated in the HIPAA Privacy Rule. And both Stacey and I have had the experience of giving talks where we mentioned that, and people go, oh, how can this be true that you could actually use my information to treat my neighbor or my sister or my cousin, who I just really can't, if I had a cousin I couldn't stand or whatever. I mean, this is really a surprise to people, but it is true. The answer is that, and HHS, in the guidance that was issued very recently about COVID, made it explicit. And this doesn't have anything to do with a waiver here. Made it explicit that for treatment means for treatment of anybody, not just the patient in whose record the information actually is.
Oh, that is very interesting. And sort of a related question about usages. I want to go back to Stacey for a minute and ask about some things that have been in the news recently. So we've heard about celebrities who have been infected with COVID-19, including Tom Hanks and Rita Wilson, Rudy Gobert from the Utah Jazz, et cetera. And I'm wondering if HIPAA permits a covered entity to disclose information about a famous or even a non-famous person and their COVID diagnosis to the media or to the general public.
The short answer is generally not. So unless that doctor or that hospital gets the patient's prior written authorization, they cannot disclose a patient's positive or negative or even inconclusive test result to the media. Now, of course, patients themselves are free to share whatever they want about their COVID diagnoses. So you have seen several celebrities like Tom Hanks and Rita Wilson kind of come out and talk about their COVID diagnosis, talk about their symptoms, talk about their relatively quick recovery, and patients are always free to share their own information. But before a doctor, a hospital, or a laboratory could disclose this to the media, they would have to obtain the patient's prior written authorization on a HIPAA-compliant authorization form.
Okay, so it's not permitted to release information about a famous person or even a non-famous person's diagnosis without their permission. What about a situation where a covered entity, such as a covered physician, is there any situation where a covered entity, such as a covered physician, could disclose the diagnosis without the patient's prior written authorization? And if so, to whom and for what purpose? I'll direct that one to Leslie.
So I'll start by talking about for treatment. So HIPAA actually divides uses and disclosures of information into three big buckets. One bucket is the one for which essentially nothing from the patient is required. So that's treatment payment or healthcare operations would be a primary example of that. The second bucket is uses and disclosures for which written authorization is required. And that's a very technical requirement. And Stacey mentioned a very good example of that is disclosures about, say, somebody, a famous person, or even my neighbor to me, their COVID diagnosis. The third bucket is a bucket in which the patient is supposed to have an opportunity to object, but doesn't. Now, in that bucket is the directory information. Stacey told you about that already. Also in that bucket is information related to the patient's episode of care to persons involved in that patient's care. So that could be close friends or family members who may be very worried about the patient. Now, I worked with some ICU doctors a couple of years ago because being in an ICU is deeply traumatic for patients and family members. It's doubly deeply traumatic now with isolation protocols. So people may be very hungry for information. And so it is important to know that more detailed information can be shared about this episode of care or to people directly involved in the person's care. It's not anybody who calls up the hospital. Those are people who are directly involved in the patient's care. That's why your partner can also pick up your prescription from the doctor's office. You have an opportunity to object, and it's reasonable judgment not to. Now, if patients can't be consulted, providers can use their reasonable professional judgment about what's in the patient's best interest in this context, and then, of course, ask the patient whether this should continue later on. Stacey is, I think, going to say a little bit more about disclosures to public health, which also don't require authorization.
Yeah, so another provision within the privacy rule at 164.512b, of course, allows covered entities to disclose protected health information to public health authorities, like the Federal Centers for Disease Control and Prevention or a state local board of public health, for purposes relating to the prevention or the restriction of the spread of the disease, and also for public health investigation, public health surveillance, etc. So I've heard a lot of people say, like, how is it that my COVID diagnosis is ending up in the Southern Nevada Health District Board's hands? And it's because of 164.512b within the HIPAA Privacy Rule that permits that disclosure. We are essentially minimizing privacy to encourage public health initiatives that can help stop or prevent the spread of this disease.
Yeah, and that would also be something that would be happening, obviously, with more frequency right now because of the urgency of the situation that we're in. Now, another issue that's come up and has been discussed a lot in recent days is how Google and other tech companies are releasing de-identified patient data to researchers so that researchers can use the data to determine whether people are social distancing or whether social distancing is effective in preventing or lessening the spread of COVID-19. Are these tech companies violating HIPAA, and what are some of the other privacy implications here?
That's a great question, and that is my current law review article that I just submitted a few weeks ago. So a lot of these tech companies, remember, they are not HIPAA-covered entities. They're not health plans, they're not healthcare clearinghouses, and they're not healthcare providers, and some of them are not business associates, which means the HIPAA Privacy Rule does not apply to them. Now, again, we have these pending federal bills that would apply to them, but these bills have not been enacted. And remember, at the state level, we have kind of generic, like, data breach notification requirements, et cetera. But a lot of these tech companies are not regulated by the HIPAA Privacy Rule. Even if they were, though, remember the privacy rule contains a de-identification safe harbor, which allows the removal of 18 different identifiers. And once those identifiers are removed, the information is not considered protected and it can be freely used and disclosed. So the article I'm currently working on talks about state data de-identification standards and how they're not really up to the task given advances in artificial intelligence, machine learning, and data analytics to re-identify the subjects of these allegedly de-identified pieces of data.
Okay, so another new development that we've been seeing a lot of in the last couple of weeks since this outbreak has gotten serious is that many patients are communicating with their healthcare providers in new ways, online, using telehealth technologies. And this allows them to have virtual appointments without risking face-to-face interaction. So I wanted to ask Leslie how those kinds of interactions are related to the HIPAA privacy regulations, and do these interactions violate HIPAA? Are there concerns related to that in this new world where we're seeing so much more telehealth?
Yes, this is it's a super important question because of telehealth. As I gave you the example of my own husband's visit to the dermatologist just yesterday. So just to give you a little bit of historical context, the original Health Insurance Portability and Accountability Act, HIPAA, was enacted by Congress in 1996. The Privacy Rule, first version 2000, second version 2002. Facebook wasn't even a gleam, I think, in Mark Zuckerberg's eye. It first hits the world in 2004. Twitter hits the world in 2006. And the first iPhone goes on the market in 2007. So we've got a rule that I use the word antediluvian almost, although there's some, for example, the security rule is meant to be flexible to include new technological developments. But basically, the framework that we have was put into place before the current world of social media. Now, in the guidance that HHS put out, the important difference with these modes of communication to whether HHS is going to exercise its enforcement discretion is whether the device used is what's called public facing or private facing. It's private facing if when you get on it, its default settings are private and you've got to override them. It's public facing if they're not. So Skype, Zoom, FaceTime, Facebook Messenger, Google Hangouts, WhatsApp video chat all have default non-public facing modes and were explicitly mentioned by HHS. On the other side are modes of communication like Facebook Live, Twitch, Slack chat room, and TikTok. HHS stated in that March 20th statement that it would exercise its enforcement discretion not to impose penalties for HIPAA non-compliance when these non-public facing modes are used for telehealth. This notice applies to privacy, security, and breach notification when telehealth is being used. HHS also recommends very strongly using encryption functions and encourages providers, that's their language, to notify patients that use of these apps potentially introduces privacy risks. There are some vendors that have indicated their HIPAA compliance and that they will enter into business associate agreements with providers. And that's actually interesting because whether you're a business associate or not, you don't get to decide. It's whether or not you get protected health information. So Skype for Business, UpDocs, VC, Zoom for Healthcare, DoxyMe, Google G Suite, Cisco WebEx, Amazon Chime, GoToMeeting, and Spruce Healthcare Messenger are among the ones mentioned by HHS. So any telehealth, all providers of organizations that furnish, bill, or are paid for healthcare in their normal course of business. It's not limited to COVID treatment. The one other exception, however, that people ought to be aware of is this waiver of enforcement discretion. This waiver of HIPAA enforcement does not apply to the substance abuse and mental health treatment Part 2 regulations. So that's the only place. So if your SAMHSA covered and you're doing telehealth, you're not within the waiver.
Okay, thank you. There's a lot of information and a lot of variation, and so obviously anyone who's engaging in telehealth should be aware of some of those changes that are going on right now. I wanted to ask to see if either of you had heard about any reports of HIPAA violations that have occurred in the context of COVID-19.
On Monday, I did read an article published by Bloomberg Law reporting that the city of Los Angeles sent an email to 200 people giving them negative COVID test results. But instead of line copying or BCCing all the emails, they just CC'd them. So the result is that every recipient could see the email addresses of all 200 recipients and the fact that they had a negative COVID test result. And even a negative COVID test result is information about a person's current physical health condition, and an email address is an identifier under the de-identification safe harbor. And I did a little bit of research, and the city of Los Angeles has designated itself as a hybrid entity, which means it's admitting that it has covered healthcare components that have to comply with the privacy rule, as well as non-covered healthcare components. So depending on where in the city of Los Angeles the email came from, depending on a couple of other things like that, if we don't have those 200 patients prior written authorization, there may be some problems with that disclosure.
Okay. So I want to spend our remaining time looking a little bit toward the future and what we might, some issues that might come up and that we might expect to encounter in the near to midterm or even longer term future. So one thing is that I can envision that if we get to a place in a couple of months where the restriction, the overall stay-at-home orders are loosened, but that in order to go out and work and to re-enter society without restrictions, you have to be able to show that you have immunity to COVID-19, that you've recovered from the infection. Obviously that's information that is closely connected to people's health records and would require people to reveal health information in order to be able to re-engage with society in a complete way. I wanted to ask what your thoughts are about that. How would the existing privacy regulations and other considerations work out in that kind of scenario? Obviously, we're in the place where our new world that we're going to see after this outbreak requires revealing more health information than we might have had to in the past.
Yes. So under the current privacy rule, there's two ways it could occur. A patient could himself or herself self-disclose their immunity status and hopefully get to move around and work that way. So that's no problem. The problem I see there is whether the employer or the government would trust that self-disclosure. A second way under the privacy rule, as it's currently written, is of course a patient could sign a HIPAA-compliant prior written authorization form for their physician, their hospitals, their labs to disclose their immunity status. And this one, I'm really curious about what Leslie thinks here. This morning I was thinking about this. Right now in the privacy rule, we have a provision that allows covered pediatricians and other doctors to disclose to elementary, middle school, and high schools vaccine and immunization records in areas where those immunization records are required for kids to enroll in school without the parent's prior written authorization. And I am curious whether Leslie or anyone else here thinks that there should be a parallel provision for that in terms of disclosing immunity or antibody or some other type of COVID-related status for purposes of returning to work or for purposes of ensuring the government that we should be free to move around. It's very controversial.
I think it's very controversial. It would take a rule change.
Yeah.
There's another way, which is reports to public health. For public health, can be used in contact tracing.
Yeah.
And people shouldn't forget that. I wanted to put one last thought on the table, which is as we go forward, which is telehealth is, I think, here to stay. And I think it's really important to make sure that to the extent that novel forms of communication are used, they don't link up to the electronic medical record for security purposes. Now that's inconvenient for providers because they've got to re-enter the information, as my husband's dermatologist said he was going to have to do after the visit. But still, I think it's critically important because of the security worries about the information in health records.
Okay, well, that is a really important point, and I think we are out of our time for today. So I just want to thank our guests, especially thank the input here of Professor Francis and Professor Tovino for a really exciting and interesting conversation. These issues are going to continue to develop. We are going to be broadcasting here on Twitter at noon every Tuesday, Wednesday, and Thursday. Go to Public Health Law Watch, which is at PHLAWWATCH, or search for hashtag COVID Law Briefing for more information about our upcoming discussions. Show notes are also available at the Public Health Law Watch blog, and the shows are archived by the Week in Health Law podcast at www.twihl.com. And the COVID-19 law and policy briefings are produced, and I want to give special thanks to Faith Kalick and Bethany Saxon, who really help us put all of these discussions together. So we'll see you next time. Thank you. Have a great day.
Thank you.
Please stay safe.
Yes, and stay safe.